Welcome back to the next episode of TMT with Mike O'Reilly. My guest is Ilya Shapiro of the Manhattan Institute, Director of Constitutional Studies, I should say. And I was hoping we could explore some of the First Amendment issues that have been so prominent at the end of the Supreme Court term. For many viewers, you may remember a few weeks ago I had famed litigator Floyd Abrams in one of my episodes, and he talked about what was going to happen, what he thought might happen, and you're getting to explore the issues after they've
Was
occurred.
he right?
You know, on most of them he sort of was, but then we'll get into that. Some of the cases were decided on procedural that he wasn't thinking might be. So you get to see some hindsight on how things played out. So let's start with an easier question. What is the Manhattan Institute's role and mission and focus? And then what's your position within that institution?
Well, sure. Well, first of all, thanks for having me. I've enjoyed working with the Free State Foundation over the years, and I'm always happy to talk about the First Amendment, especially since everybody else seems to want to talk to me about Trump's immunity claims, the overturning of Chevron, very important, but First Amendment is always important. The Manhattan Institute is a think tank. It's broadly center-right. It's a pretty big tent. You can, whether it's libertarian, social conservative, neoconservative, reform conservative, there's anybody within our halls of different sorts of people. Based in New York, as one would expect, although I live here in Falls Church, Virginia. I like to say that I head up the elite Falls Church office. I think it's 47 years old, and is really the think tank. Its comparative advantage among center-right think tanks is being the think tank for city issues, urban affairs and policies. So whether that's housing, policing, education, those very bread and butter things. We don't have a foreign policy department. We don't have an international trade department. I don't do those kinds of city or urban specific issues. And that's part of the reason I was brought in. Because I complement everybody else, and I've always enjoyed learning about different issue areas. And I have more of a national focus, and I have a Supreme Court and legal constitutional focus. They've never had a full-time dedicated constitutional person. So when I left Georgetown, this was a very good fit to join my friends who I'd known for a long time at MI and to build their amicus program. I think before I came, the first 45 years, I've now passed 2 years at MI, first 45 years, they filed something like 4 or 5 amicus briefs. We hit 30 my first year. So that's what we do, including in First Amendment issues, but of course, not only. And so I've continued some of the work that I was doing at Cato, where I spent almost 15 years. But quite apart from whatever ideological differences there might be between MI and Cato, one thing that's been very interesting and kind of a fresh change is MI focuses a lot on government affairs. So I've been meeting with attorneys general's offices, senators' offices, governors, things like that, trying to actually move the ball on policy. It's a neat addition to what I've been doing.
And do you find at the Manhattan Institute that you're more of the lawyer or the scholar as someone who is as a constitutional expert?
One thing I've always enjoyed about my career path and where it's taken me is that I have a job that straddles the legal, political, academic, and media worlds. So sometimes I'm writing or editing a Supreme Court brief. Sometimes I'm writing or editing an academic article. Sometimes I'm going on TV. Sometimes I'm debating professors. Sometimes I'm meeting with government officials. So it's un poco de todo.
Do you, where would you place yourself on the spectrum of First Amendment positioning? Can you be the strict constructionist, the text be damned, or is it it's being used and abused too often?
Well, I don't know what strict constructionist even means in this context. We have the most free speech protecting court, I think, that's ever been, that we've ever had in this country. And yet sometimes we have dissents because the court's not being originalist enough, or sometimes we have dissents that it's not being free speech protective enough. So I don't know. I generally agree with my friends at FIRE, who are very, very protective of free speech, although we can go into this. I disagree somewhat with them on some of the social media regulation cases or some of the applications of First Amendment doctrine since October 7th, for example, with what's going on campus. But I'm a pretty hearty supporter of free speech in various contexts. I thought you were going to ask where am I on the spectrum between like an activist and a scholar, and I'm sort of balanced in between there as well.
And I read with interest, a great interest, your piece that where free speech ends and law breaking begins. Can you walk us through a little bit your thoughts there?
Sure. That was back in late October, early November when I published that, for the Free Press, Barry Weiss's fantastic publication. And she asked me just to write a normal op-ed length thing about what's going on college campuses, the Hamas protests, and all the rest of it. It ended up expanding into a 2,500 word primer on the subject. And there's really three areas to look at here, and I think it holds up 6 or 8 months later. There's things that are not speech. So if you commit assault or vandalism because of some motive that's to express your political views, that doesn't make that vandalism or assault constitutionally protected or protected by the speech policies of universities that they have, which generally track the First Amendment in most places. So, the most kind of colorful example of this that I came across was somebody urinated on a Hillel and then claimed the defense that this was being expressive. No, you don't get a defense against the public urination law for being for a political motive. Then there are exceptions to speech. So, for example, the Supreme Court has held that if you incite violence, that is not protected First Amendment speech, or that if you levy a real death threat. And there's settled jurisprudence about what that means. Pretty high bar. We talked about incitement in the context of Donald Trump on January 6th. Now got familiar with it again. So just saying offensive, hateful things, that's not enough to qualify as incitement. It's like saying, for the rest of the day, anytime you see a Jew, punch them in the face. That qualifies, and that's not protected speech. And then there are time, place, and manner regulations, and that's where the bulk of the debate has been. So, for example, even core political speech that's at the heart of the First Amendment, talking about politics, right? Everyone agrees that's the main, whatever we might think about flag burning or exotic dancing or some of the kind of the edge cases of protected expression, we all agree that political speech is and should be protected by the First Amendment. Well, I can't go into your neighborhood in the middle of the night and with a bullhorn tell you and your neighbors exactly what I think of Joe Biden and Donald Trump. That's disturbing the peace. Similarly, blocking the road to express my political view about Donald Trump or Joe Biden or the Israel-Gaza war, anything. You can't block the road for that reason. That's why we have such things as parade permits and things like this. On the campus context, there are rules that you can't disrupt classes, or if some student group has reserved a space for a speaker, you can't come and shout down that speaker. All of these sorts of things that make sense, even though you do have a right to speak, but there can be these kinds of limits on it.
Do you think, the last part of your question, or your answer there, do you think that when we come back into fall, do you think the college campuses are going to have learned their lesson, the administrators have learned, or are we going to see a return to the springtime?
People respond to incentives. When the University of Florida suspends people for 4 years for violating the rules, not for engaging in hate speech or offensive speech or anything like that, but for blocking access, for violating neutral rules, I don't think this thing is going to happen at University of Florida. When Harvard reverses the suspensions of people who committed vandalism and assault and all the rest of the things, that means you're going to get more of that.
So let's turn back to the Supreme Court and recent decisions at the end of the October 2023 term. Do you think that there were any common themes on the First Amendment issues that they decided? Is there any thread to pull from? Is that kind of a Roberts trait, some balancing perhaps, or how we've used different cases and who gets which decision to write?
We've had blockbuster First Amendment years in the past and cases. This year was shaping up to be that way with the major social media regulation cases of different stripes. Public officials using their accounts, and how do you regulate that? Or states regulating the tech companies, or the government colluding with tech companies to suppress speech. All of those could have been major refinements or revolutions in the doctrine. They turned out not to be. They turned out to be standing or other technical decisions. You can't bring this as a facial challenge. So I think the court was either wary of rocking the boat too much because it involves technology, and the court generally treads lightly in technology cases because they don't want to decide something that 2 years later, 5 years later looks hopelessly outmoded. And it's probably because it's it's a 3-3-3 court in the sense that the middle three, Roberts, Kavanaugh, and Barrett, tend to control in the close cases. And they didn't want to go too far. And they wanted to find an out, like withstanding in the Murphy versus Missouri case, to not have to create new doctrine in that case with respect to job owning.
Were you surprised by the Murphy decision?
I was.
And maybe outline how the court approached it.
Sure. So I filed a brief in Murphy supporting the challengers. I thought this would be an opportunity to update Bantam Books, which is effectively the government exerting pressure on private companies or businesses to do its bidding and to doing things that the government can't do directly. What everyone agrees would be a clear First Amendment violation if the government was doing directly, but here it is using carrots and sticks to get private businesses to do it. And that seemed like what was going on during COVID, the coordination between government offices and the tech platforms to suppress in various ways, shadow ban, block accounts, etc., of people that were talking about COVID in ways that the government thought was disinformation or harmful or what have you. And I thought, well, they're going to have to draw some sort of line, maybe even if it's remanding under a new standard, okay. But they didn't make any new law. They said that there was no standing for the people that connected the people being harmed to government action. That is, Justice Barrett wrote the majority opinion and said, you may well have been harmed. It looks like you were censored by the tech companies, but you're not suing them. You're suing for breach of contract or whatever. You're suing the government. And I can't connect the dot between the Surgeon General making a speech or some other person from the White House sending an email and your account being disabled. I thought that I didn't agree with that. I thought Justice Alito's dissent was correct, especially the one lead plaintiff, or the one that had the strongest case, as Justice Barrett said. I think Rebecca Hine is her name. It's if in effect the court was saying that without a smoking gun, without an email saying explicitly shut down Ms. Hine's account, you're off scot-free. That can't be the right rule. So there's another case called NRA versus Volo, where there was a smoking gun, where the relevant New York State official told insurance companies, don't deal with the NRA or we'll take some regulatory action against you. Well, that was a unanimous ruling for the NRA. The ACLU filed a brief for the NRA, open and shut case. So unless you have that level of governmental stupidity, I guess, or explicitness, is the court saying that you can't have a case? That's bizarre and disappointing. And there were people, expressing surprise about that, I think, across the political spectrum.
Is there actually, who does get standing? As I read the case, as I listen to a lot of experts on this, it's hard to see who could capture standing. And then, therefore, the second part of this: how do you get the discovery to actually have the smoking gun? How do you show the government in bad faith if you can't get the in the front door?
Apparently, giving speeches or even emailing to the tech companies, we really don't like. People discussing this study that the vaccine isn't effective or can't, doesn't prevent airborne transmission or something like that. That doesn't give people standing who are talking about that. It has to be more specific that, John Smith has been talking in a way we don't like. He should be shut down. Is that really what it takes? I found that bizarre. I thought maybe a little of what was going on is that at least that those centrist three justices thought, okay, a lot of weirdness going on during the pandemic. We're not going to continue this unusual excursion into pandemic law. We'll see what happens going forward. If there's allegations of continuing things that's not just for the limited time like the pandemic, maybe we'll take a look at that again.
But has the court made it harder in Murphy? Has they made it harder to bring that next case that you just described that's outside of the pandemic?
I think so, but honestly, the court standing doctrine is beyond me. And I asked Paul Clement, super lawyer, argued over 100 cases every year because there's always new standing cases. I'm like, okay, remember we talked a year ago? What do you say now? And sometimes he just throws up his hands.
Okay. You mentioned the NRA case. Do you see, as someone who studied the court over the years, do you find that they do this kind of balancing? We're going to show you guidelines over here and be very clear over here, and we're going to set, we're going to balance that out so the court doesn't look, in this tumultuous time too outlandish. We're worried about our image, or do you just find that the majority is just, had a position and let the cards fall where they may?
Well, John Roberts, the Chief Justice, and I think this term showed that it really is the Roberts Court. There had been questioning, since he's the sixth man, not the median vote anymore. Although he became the median vote again this year, was most in the majority. I think one more case than Justice Kavanaugh. And he's the minimalist, so maybe he doesn't matter as much. But I think he clearly does, and he always tries to have the most narrow opinion possible. Sometimes that can't happen. Sometimes you have several cases where he warns, if this doesn't change, we're going to have to drop the hammer down, as happened in campaign finance, as happened in voting rights. I guess in some of these cases that had these surprising narrow technical decisions, he was able to convince Justices Barrett and Kavanaugh to go along with him. I think in part in Barrett's case, she doesn't really like to provide big merits opinions when it's an early stage of the case on interlocutory appeal or some other procedural thing that's not reviewing something that's been fully adjudicated.
So let's turn to the social media cases. You had the Moody versus NetChoice and NetChoice versus Paxton. I think most people left unfulfilled, and partly because both sides claimed victory. Is there something to take away from that feeling, that there was no clarity, or are we just setting ourselves up for 3, 5, 7 more years of the case, or similar cases flowing through?
Well, it seems like both sides did win, in the sense that it came up on a circuit split. Effectively, the Florida and Texas laws aren't identical, but they both, in broad strokes, try to require social media platforms not to discriminate based on viewpoint for various reasons. But anyway, the 11th Circuit invalidated the Florida law, the 5th Circuit upheld the Texas law, and now both of those decisions are vacated with instructions, dicta. We're not really clear. Again, I am confused about this case still. People are trying to read the tea leaves. Did Justice Alito, who joined by Thomas and Gorsuch, who concurred only in the judgment, did he lose the majority? Because his concurrence seems odd, because it's very long, goes into the substance, and yet he agrees on the judgment. Did Justice Kagan, was that originally going to be a dissent of some sort? And the ultimate ruling is it's very hard to make out facial challenges, go back and have an as-applied challenge. And then, and yet they give a lot of what lawyers call preview, not binding, I guess. So I guess it is dicta, but the writing's on the wall if you're going to be reviewed by the Supreme Court again. And Justice Barrett explicitly says, I think the 11th Circuit is more right than the 5th Circuit. I mean, this is not a stereotypical vacate because you applied the wrong standard. And these are not, these are knowledgeable, thoughtful lower court judges. Kevin Newsom of the 11th Circuit, Andy Oldham of the 5th Circuit, considered to be among the more intellectual of the lower court judges. So I don't know what exactly was going on there behind the scenes. Maybe it's right that, the laws are so broad that you have to look at their specific applications. And that could be a good result ultimately, because when I was looking at the laws, I did like certain parts and didn't like other parts. As a lawyer, I don't mean as a policy matter. So it could well be that they'll be taken up more piecemeal by specific platforms harmed in one way or another.
You talked about the Roberts Court and the 3-3-3 kind of split. Has this term really solidified the view that the conservative cabal doesn't exist, and that you're going to see kind of this going forward? Or is it, as critics have highlighted, that this is just an aberration, and we're going to go back to why packing the court is necessary, or some kind of action is necessary because the conservatives are all ganging up?
Well, leftist activists are never going to give up the drumbeat for a packed court because they don't control it. They don't even have a kind of a 4-4 with Justice Kennedy human jump ball in the middle. It's the court is, I don't think you can deny it, a fairly conservative or originalist, textualist, things that the Federalist Society likes as opposed to the American Constitution Society. But half the decisions, nearly half, were unanimous. Only 11 of the 58 or 59 were 6-3 in a so-called ideological way. And there were plenty of cases where that middle three joined with the liberals in 6-3 going the other way. Then there was some completely heterodox things. So it's not just win after win after win for conservatives. And for that matter, the court takes up a lot of cases to rule against the Fifth Circuit, especially this year, which for the first time since I became a court watcher had a bigger losing percentage than the Ninth Circuit at the court. So it's the court is certainly one that conservatives are going to be, all things being equal, more pleased than progressives. But it's that centrist faction that controls. And you can tell that by who's in the majority more. As I said, Roberts and Kavanaugh, and very closely behind them, Barrett. Then it's a jump. Last term, the progressive justices were more in the majority than Alito and Thomas. And last term was supposed to be this big conservative term because of Bruen, the gun case, and the overturning of affirmative action. So you can write these narratives and these themes, but there's a small number of cases at the end of the day. And the statistics belie the vibe. Until the last 2 weeks of this term, it was not a conservative term at all. It was not an ideological term. But of those 11 6-3s, I think 8 of them came in the last 2 weeks. So again, it's what you're left with, and you have this whatever psychologists call it, the availability heuristic or the near time heuristic or whatever. You're all thinking about Trump immunity, overturning Chevron, something else, and you forget some of these earlier things that, oh, well, the court compromised here. It went the liberals' way.
Cut that out. You mentioned the presidential immunity. Do you see that as a part of that conversation, as a First Amendment viewpoint, or was it on other analysis as the court kind of ruled?
Well, the First Amendment, the court wasn't talking about the First Amendment, although certain circumstances where lower courts will now be charged in evaluating alleged official acts that have a presumption of immunity. If a president gives a speech, that's a First Amendment activity. But you can be charged for inciting violence, as I said. So if the president actually is inciting violence, is he doing that in his presidential capacity, in which he might be immune, or is he doing it as a personal capacity or his capacity as a party leader or candidate? So the First Amendment comes in that context if he's going to be charged for Trump or any future president charged for First Amendment expression, but it's not specifically a First Amendment case.
What did you think? Obviously, the flurry at the end of the term, but there were a number of cases earlier in the term on trademark law and a couple other areas. Did you find those to provide an overall path, or were they smaller cases and they saved the humdingers and then they still decided these on procedural grounds? Did any of those provide any more comfort in terms of the First Amendment?
Comfort. Well, I disagreed with Vidal v. Elster. That was the case of the trademark. Someone wanted to trademark Trump so small, and the court upheld the law prohibiting the use of someone's name without their consent. I believe that's what the ruling ended up being. I thought this would be of a line of Mattal v. Tam and Iancu versus Brunetti, where you can't restrict speech in that way, that it's the company's speech, the business's speech, not the government, not the trademark office's speech. But it went the other way because there's reputational concerns and what. I don't think that's a major First Amendment case. I thought I would have gone the other way. The other social media regulation case are the public officials, school board officials, and others who were or were not, again, remanded for fact-finding and or determination as to whether they were using their campaign accounts to communicate official business. And then when they blocked certain people, was that a violation because they're public officials now? And not surprisingly, the court unanimously there said, look, if they're, it's about the substance of the communications, not whether it's labeled as campaign Facebook page versus private versus official. So that I think is probably the right rule going forward. But I don't try to draw much. I could if forced because I'm a writer and I can paint a picture of that sense. But I like the court. I take each case as they come, and I remain convinced that this court is the most free speech protective, First Amendment friendly that we've ever had.
So in the upcoming term, where the court has signaled that it's going to take a case involving the online a law statute that prevents or requires modifications for adults and to verify your age going forward. And you're likely to see copycat states. There's a number of states that follow this. So come age verification going forward. And I know it's early to we're 4 briefs. We're way early. But does that strike you as something that the court has viewed in the past? And where do you see that going in this very First Amendment protective court?
Yeah. This is completely top of my head. I haven't looked at the lower court rulings. I haven't read any briefs. But I think they're going to have to update for the internet world, for the digital world, rules like that you can't broadcast certain things during a time when young kids might still be awake and watching TV, or the way that states and municipalities regulate where you can place porn mags in your kiosk and things like that. Those sorts of rules have been upheld in the past. So how do you do that in the digital space? The court's going to see whether the regulation is overly broad, that is suppressing speech that doesn't need to be suppressed. Is it too burdensome to have this age verification? Does it even accomplish what it hopes to accomplish? Is it too easy to circumvent for a clever 13-year-old? Things like that. I think that's how to look at it.
So in closing, when you look at the court in totality, does if we were to expect a new Supreme Court justice in the next administration, whichever way that may go, and I'm not engaging in any projections, do you see that dramatically changing the court, or do you see, as kind of you outlined, the Roberts Court has a particular viewpoint, and the leaders that they approach these issues, and we're likely to see more of the same going forward?
There's a critical mass of justices, a super critical mass, if you will, a supermajority of justices who are very free speech protective. I think 15 years ago, the leading, and this cuts across conventional ideological lines, I think 15 years ago there was a study that showed that the justices that most protected speech were Thomas, Kennedy, and Souter. So left, right, and middle. And I think that dynamic has continued. Gorsuch is very speech protective. Thomas has dissented about kids' speech rights, I think, because he looked historically at what rights kids had at the time of the founding and things like this. But I think generally speaking, we're at a time and we're in a polity that expects broad speech protection, and both the left and the right don't like it when the government is intruding on that.
Last question: do you think that the court's reputation has been tarnished in the last many years, or the critics and the justices just are going to continue to do what they want to do, and the court has shown that it has to do what it thinks is right, and as I said earlier, let the cards fall where they may?
I think those that decry the court's lost legitimacy are the ones responsible for that dynamic. It's almost a self-fulfilling prophecy, in the sense that the court is still a relatively respected institution relative to other institutions. At the federal level, it's, wherever its popular confidence is, it's way higher than for the president, for the Congress, for the bureaucracy, basically any institution other than the military, which also has taken a hit. And that's the thing. We're at a time of record low public confidence in institutions writ large, since polling began effectively. I think lower I've seen than in the post-Watergate era, for example. And the biggest difference isn't the overall drop in public confidence in the court, but the difference between conservatives and liberals, or Republicans and Democrats. And we're at a time where that gap has never been bigger, even as the court's confidence overall level is not doesn't concern me. I don't think we're at the point where if the Democrats control all parts of the federal government that we'd have court packing. That's a dangerous thing. It polls poorly. It's seen as illegitimate in and of itself. But I do think it's unfortunate that we have this narrative. Well, we're recording this a couple of days after the attempted assassination of Donald Trump. And Chuck Schumer, when he was talking about on the eve of one of the abortion cases 5-6 years ago, that Kavanaugh and Gorsuch are going to reap the whirlwind if they rule badly on that decision. I think people are either being disingenuous, or they just truly don't understand that law is different from politics. And there was hardball that Mitch McConnell played, for example, in keeping that seat open after Justice Scalia died. And it was hardball to force through Amy Coney Barrett after Justice Ginsburg died. But that's politics. That's not violating any legal rules or anything like that.
Well, I can't thank you enough for your time. I really appreciate your insight, and look forward to touching base with you in years to come on future First Amendment cases. Thanks for your time.
Sure, and your listeners, your watchers can read about all of those things that we were discussing in my last book, Supreme Disorder: The Politics of America's Highest Court, and my next book coming out in January, Lawless: The Miseducation of America's Elites, about problems in law school education.
Outstanding. I look forward to reading it. Thanks for your time.